So it's been another heated week at the Ad Hoc Committee probing corruption and political interference in the justice system as witnesses faced scrutiny from members of parliament. The National Director of Public Prosecutions, Shamila Batohi, conceded that South Africa is losing the battle against organised crime. She admitted that the criminal justice system is broken, leaving citizens vulnerable. And as if that was not enough, MPs also slammed Police Ministry Chief of Staff Cedrick Nkabinde, accusing him of deliberately misleading the committee with incoherent testimony. For more on that now, we are now joined via video link by Advocate Emmanuel Netshipise from Mudau and Netshipise Attorneys to help us unpack this crucial inquiry. Thank you so much for your time, Advocate. Perhaps let's start with getting a better understanding and unpacking what are the legal requirements for a witness statement that is submitted to a parliamentary committee and the implications thereof, and just looking at just how serious this should be taken.
Thank you very much, sir, and your viewers. Of importance is to note that these statements are taken under oath. Then when a statement has been taken under oath, it means that it has been administered in terms of an act of parliament, which requires that whatever contained thereof in the statement, it must represent the honest truth, which subsequently to being disposed to by the author thereof, it is administered by the Commissioner of Oath. The legal effect of that is that anything that is deposed by the author, which is then found to be untrue and then made deliberately knowing that it is untrue, it amounts to perjury.
And, you know, the assumption usually is that when a person takes a certain oath or an affirmation as they just about to give evidence, is that they will tell the truth as best as they know how, as best as they can recall. Just what powers does the Ad Hoc Committee have if it believes a witness has withheld information or misrepresented facts?
Thank you very much. There is an evidence leader at the Ad Hoc Committee who leads evidence of these witnesses. Then the evidence leader can point out to the contradictions, maybe by referencing to evidence which has been given by the prior or previous witnesses and ask for clarity from the witness concerned. Then other than that, there is nothing that they can do other than maybe creating an adverse inferences on the evidence of the witness concerned, maybe to rule out the evidence as untruth.
Yeah, and based on those, you know, potential sort of implications, Advocate, just moving forward, what potential strategic motivations for improving or expanding a statement are available to these witnesses when it comes to deposition, for example, and also looking at, you know, some of the topical issues which has been around the Sharnik issue as well as dockets?
All right, thank you very much. It happens sometimes in practice that you'll find that at the time of deposing a statement, one misses some material information or relevant information, or such information becomes available later after one has deposed to a statement of this nature. Our law does allow for a supplementary statement to be deposed, which then record the new information which was not recorded in the initial statement. So a supplementary procedure is what is accepted in our jurisprudence.
And what does it mean legally when, you know, police say they are preparing dockets for referral? Because that is something we've heard on many occasions as this Ad Hoc Committee has been unfolding.
All right. Ordinarily, after the case will have been opened, police will undertake a process of investigation. When they are done, or when they believe that they have sufficient evidence which can maybe warrant prosecution, they then refer a docket to the National Director of Public Prosecutions for the latter to make a decision in terms of whether to prosecute or not. So in this context, Referral, in my view, will mean referring a docket to the NPA for decision whether to prosecute or not.
And Advocate, just how fit for purpose are all these processes? Because I know many critics on some end have even said these processes are sort of like all bark and no teeth in a way. Just how watertight are they to ensure that not only these are processes that we're seeing for accountability, but these are processes that will be seen through and there will be some sort of action taken for those that are found to be in the wrong?
I do not form part of those who believe in a school of that of believing that these processes are just paper tiger, because these processes they give us an indicators. They give us an indicators for the subsequent proceedings to take place. You need a base, first of all. So these processes have given us a base. Then following evidence which is being given in these processes, then a variety of institutions can now undertake internal investigations to establish the correctness of the evidence which they might have had in these processes, which without these processes they would not have known. So in a nutshell, I think this process is of assistance, because I'm of the view that where we are seated now, there must be many internal processes which are underway now, following what we have had from these processes. Then there will be result. It is just that institution cannot wait for these processes to make recommendations. They've got a duty to act. Act, I mean, by following whatever leads that they will have had from these processes and make decisions following investigations.
Yeah, and also to zoom in now to the National Director of Public Prosecutions, Shamila Batohi's sort of moment there on the hot seat. Advocate, you know, we heard how she kept saying that, you know, she'll have to refer to documents when she was quizzed on some of the cases that the NPA is currently investigating. Just at what stage does the DPP perhaps become directly involved in plea agreement considerations, directly so?
Thank you. There are hierarchies within the NPA in that the case will be allocated to a prosecutor. And then the prosecutor will have a senior prosecutor that he or she will consult with in matters of decisions pertaining to the prosecution of the matter. Not all the time. Sometimes decisions like representations that has been made by the accused person's concerns might be taken to the senior prosecutor for decisions. Sometimes if the decision from the senior prosecutor is not favorable to the accused person concerned and he or she want to escalate the matter, then the matter may go to the Deputy National Director of Public Prosecution up until it gets to the National Director of Public Prosecution for decision. So a long and short of it is that not all matters will be brought to the attention of the National Director of the Prosecution due to the hierarchies. There are many stages wherein prosecutors have got jurisdiction or powers to make decisions themselves without having to inform the National Director of Public Prosecutions.
All right, I must thank you so much for your time. That's Advocate Emmanuel Netshipise from Mudau and Netshipise Attorneys, helping us there unpack this crucial inquiry. Thank you so much for your time and insights on the program.